Nous sommes en audience publique, Monsieur le Président.
عدنا للجلسة العامة. تقول موظفة قلم المحكمة. القاضي الرئيس، شكرا جزيلا لموظفة قلم المحكمة. والآن سألتفت إلى السيد الحسن لكي نطلب منه ما إذا كان قد فهم طبيعة التهم الموجهة إليه، ولكي نعطيه الفرصة لكي يعترف بجرمه وذنبه أو لا، كما ورد في المادة 64 الفقرة الثامنة من نظام روما الأساسي. الدفاع السيدة تايلر تطلب الكلمة. شكرا جزيلا. تقول السيدة تايلر: أطلب من الدائرة أن نتوجه للقاضي من أجل أن ينظر في بعض القضايا المحددة والتهم الموجهة للسيد الحسن.
Allez-y, Madame Maître Montefoucault.
السيدة فوكو الدفاع. تسمعونني؟ شكرا جزيلا. نود أن نتقدم بطلب لأننا نشكك في قدرة المدعى عليه أن يوجه المحاكمة عند هذه المرحلة، فنحن بحاجة إلى فحصه من أجل تحديد الوضع وتقييم إذا كان السيد الحسن لديه القدرة أن يمارس حقوقه في محاكمة عادلة كما وردت في المادة 67 من نظام روما الأساسي. وهناك بعض التفاصيل التي وردت في الدفوع ولن أخوض فيها، فكلها تشير إلى قرار قدرة السيد الحسن على مواجهة هذه المحاكمة. ولئن أخذنا بعين الاعتبار كافة الظروف الواجهة في هذه القضية من أجل تحديد ما إذا تم تجميع بعض الترتيبات التي قد تستوعب الأثر السلبي ضد المحاكمة السريعة والعادلة، ولكن نحن نشعر بالشواغل في هذه الدائرة، ونحن نرى في الدفاع أن السرعة من أجل توفير الظروف المناسبة من أجل إصدار الحكم وتوصل المحاكمة عادلة، بالتالي فهذا يضر بالمدعي عليه. فيما يتعلق بالوقت المناسب للمحاكمة، فإن القدرة على مواجهة المحاكمة لا تتقادم، فهذا الأمر نستطيع أن نثيره في أي وقت على مدار الإجراءات، بدءا بالظهور أو المثول الأساسي أمام المحكمة وحتى إصدار حكم نهائي، وهو أمر نستطيع أن نثيره بعد المحاكمة أو في أثناء المحاكمة. وإن هذه الطلبات قد تؤثر في سير المحاكمة، وينبغي أن يتم تقديمها في الوقت المناسب من أجل مساعدة الدفاع، وهذا يثير الشكوك بشأن قدرة المدعي عليه على مواجهة هذه القضية، إن التأخير يؤدي إلى سوء استخدام السلطة التقديرية لهذه الدائرة، والتي قد تؤثر في قدرة المدعى عليه على مواجهة المحاكمة وحقه في المحاكمة العادلة. ولا نستطيع أن نفتتئ على هذا الحق من خلال حجة تسريع وتيرة الإجراءات، وقد تمت الإشارة إلى هذا الموضوع في الماضي في طلب إبطال الدعوة في المؤتمر التحضيري في 30 من يونيو، وذلك في الدفوع المتعلقة بقدرة المدعي عليه مواجهة المحكمة. وأثناء المؤتمر التحضيري فإن القاضية كانت قد أقرت بأن الدفاع
have other matters to bring before the chamber and that the chamber would receive them, as it was sympathetic to the situation the defense is facing in terms of discussing matters with its client. In that regard, the defense had to seek a court order to effect its request to visit its client in person. Given the challenges that COVID has posed against all parties and also the court, the defense wasn't able to see Mr. Al-Hassan. When the defense met him for the first time in 4 months, the defense was alarmed with the current status of their client. Engaged in a discussion with him, and based on the results of the defense's in-person meeting on that day, the defense sought to confirm or disconfirm, or even simply to understand whether or not the alarm that it sensed was valid, and asked Dr. Porterfield to have an emergency phone conference with him, who is an expert of trust to Mr. Al-Hassan. She issued a letter on July 8th of 2020, which the defense has provided to the chamber, acknowledging that he was experiencing dissociative features that result from severe maltreatment, causing serious impairment and distress, and very importantly, the avoidance of memories. She then went on to state, he is experiencing dissociation, which is a neuropsychiatric symptom in which there is a rupture in sensory experiences and perceptions of oneself and of the environment. Fitness to stand trial requires that the accused is not only able to understand the charges against him, but that the accused is able to conceptualize the outcome or the consequences of the trial that he is facing. That requires that he is able to completely assist defense counsel in preparing his defense. And that requires, looking at the fourth capacity in the Struger decision, that he has the ability to understand the details of the evidence. How can somebody who is experiencing such post-traumatic stress that they are dissociating in a way that they avoid memories, properly assist counsel in analyzing the evidence that to date it still has not had the opportunity to even investigate, in order to prepare an adequate defense? So with timeliness not being an issue by law, the defense is moving this court verbally, and has done so in writing as of 10 a.m. this morning, to order assessment of fitness to stand trial of Mr. Al-Hassan, because at this time the defense affirmatively raises the doubt that he is actually fit to proceed.
Merci beaucoup, Maître. Vous avez...
Thank you very much, Counsel. You have noted that the Chamber followed very attentively what you just had to say. Now, in reality, if I understand you correctly, you are saying that your client is not fit to stand trial for the time being, but the Chamber has been regularly seized of the matter as to whether he is physically able to stand trial or not. You cited the name of the doctor, but according to the doctor's report that I have in my possession, he has said that a clinician would have to be in a position to be able to examine the accused. We have not yet been seized of the matter. Your team filed some submissions and the chamber has deliberated upon these. I would like to remind you of a number of said decisions just after the pleas entered by the accused. I will do so. And as you are raising this issue now, I see that we have 10 minutes before the break. The chamber shall withdraw with a view to answering your question upon its return, and also read out or rather recall the decisions that have already been taken on the matter with regard to which you have filed further submissions. The chamber shall now withdraw, but before we do so, I would like to know whether the prosecutor has anything to say in this regard. Madam Prosecutor. Mr. Duterte. Mr. Duterte, good morning, Your Honour. Good morning, Your Honours. I shall try and be very brief.
The opening was set for today at 10 o'clock. At 9:57, we got everyone a courtesy copy of a defense request on Mr. Al-Hassan's fitness. This is literally last minute, 3 minutes before the opening of the trial. And this is way after the 1st of June deadline for motion requiring resolution before the commencement of trial, a deadline that was postponed to the 16th of June based on a request by the defense. Expeditiousness, Your Honors, as the ongoing appeals judgment number 1562 as underscored in paragraph 2, I quote, forms part of a trial. Procedural rules that require parties to raise certain issues at a given point in time are not necessarily incompatible with the rights of the accused. End of quote. More generally, the appeals chamber has emphasized that parties must act within a reasonable time, especially regarding objections that may impact on the expeditious conduct of the proceeding. And I'm referring to the Katanga appeals judgment number 2259, paragraph 54. In the present case, there was ample of time for defense to file such a request before and to organize an ad hoc phone call with Mr. Porterfield, as they did on the 8th of July. What they did on the 8th of July, they could have done before. There are, that being said, clear indicia that Al-Hassan has an overall understanding of a proceeding and also has the ability to provide specific instructions to his counsel. And there is insufficient evidence of lack of fitness. Defense is relying on his own consultant report, which remains to be tested. And in fact, there are indicia today of contrary that he still is fit to stand trial. In this context, the prosecution considers that the defense request for reconsideration of a decision on the defense adjournment request is moot. This late request sent this morning can be dealt with before the presentation of the actual evidence starting 25th of August. We can proceed today, and the accused will be afforded an opportunity indeed to make an admission of guilt or to plead not guilty, as you had suggested, bearing in mind that it is not an obligation. So for this reason, the prosecution requests that we shall proceed today and continue the opening. Thank you, Your Honors.
Merci beaucoup, Monsieur le Procureur.
Presiding Judge Mandua, thank you very much, Mr. Duterte. Ms. Taylor.
Mr. President, given that the defense should generally have the right of the last word, I wish to address one discrete point, one very important factual point. Possibility is the limits of the law. And until this very day, we have not been able to have an expert go into the detention unit and see Mr. Al-Hassan. And I think any expert on medical issues would laugh you out of the courtroom if you were to say that you could do a proper fitness assessment with someone you do not know on the telephone. So for the last 4 months, we have regularly, repeatedly insisted we need to go into the detention unit. We have put that in almost every filing. And in so doing, we have linked it to the need to conduct proper assessments of his fitness. We have placed all the information that we had on his fitness that was prepared before COVID in our 16th of June filing, and we asked for an evidentiary hearing so that the doctors could be here and you could question them about dissociative disorder. But what we cannot do is waive a fundamental right, even if it's not an obligation, it is a right to enter an informed plea, just because COVID has prevented Mr. Al-Hassan from seeing a medical expert. And we have been prevented from actually facilitating that and have it happen. So it's all very well and good to talk about COVID and how it's impacted upon persons, but thus far, the only counterbalancing remedies that have been given to one side of the courtroom and not the other. And as a result, it's created a significant inequality of arms. It's impeded our key defense preparation, and yet when we move the chamber for a remedy, we're being told we're not timely for reasons beyond our control. And even though issues of fitness are not static, again, we've been repeatedly saying issues of fitness will depend on his conditions. They'll be impacted by COVID. There's a likelihood it would worsen. These are issues that raise the doubt that impelled us to file today's request. We cannot do earlier what's not possible. And Mr. Al-Hassan, as a defendant in this trial, should not have these fundamental rights put in peril because of issues beyond our control and because of bureaucratic formalities that could not be fulfilled in an effective rather than illusory manner. Thank you.
Merci beaucoup, Maître Taylor.
Judge Mandua, thank you very much, Ms. Taylor. The chamber shall now withdraw. It's virtually time to take the break anyway. The break will be of 45 minutes of duration. So in 45 minutes' time, we shall reconvene and we shall hand down a decision with regard to what you have just raised. Court is adjourned.
Veuillez vous lever.
All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Presiding Judge, the hearing shall resume. Good morning to one and all. I would like to clarify that the staffing of the respective teams has not changed. Madam Prosecutor, Mrs. Taylor, the legal representatives of the victims, my thanks. Before the brief adjournment, the defence raised a matter going to the fitness of the accused to attend his trial and looking into potential for a medical assessment. And I said that there were a certain number of files tendered by the defence and that now we are minded to remedy. I therefore read the decision of the trial chamber. The trial chamber recalls that the defence had requested on the 3rd of July last that today's proceedings be adjourned. Document 927. Application to which the chamber declined to look upon favourably on the 10th of July. The 9th of July, the defence also filed another motion. In that motion, it submitted that Mr. Al-Hassan was unable to stand for trial. The chamber yesterday handed down a decision upon that motion by finding that, bearing in mind the notice given by the defence, the document had been filed at an inappropriate time and that it hadn't provided sufficient information to the effect that Mr. Al-Hassan was unable to stand trial. Document 952. The chamber recalls that yesterday, at the end of the day, the defence asked of the chamber to show reconsideration of its own decision, to decline the adjournment of the trial, or, in the alternative, to authorise the fact that this matter should be brought before the Chamber of Appeal by referring to information de novo justifying, warranting in the defence's eyes such reconsideration to be envisaged by the appeals chamber. During this morning's proceedings, the defence has made an oral submission detailing a certain number of contentions, which in substance takes up those that were expanded upon in the aforementioned submissions, in particular in the reconsideration motion that was filed by the defence yesterday. The chamber recalls that this morning, during our proceedings, the defence explicitly formulated an application to the effect that a qualified medical assessment be conducted on their client, and that this medical assessment should determine the matter whether the accused is indeed able to stand trial. Regarding the reconsideration application, the chamber considers such application. This was submitted at 17:54 yesterday. Additionally, bearing in mind its content and purpose, the Chamber does not find it necessary to hear submissions from the prosecutor or from the legal representative of victims. The Chamber dismisses the application and will provide a reasoned decision in due course. I move to the application for going on appeal. The Chamber has formally acknowledged this course of action and will hand down its decision in due course after having received responses from the parties and participants. I move to the oral application made this morning. This oral application, by way of reminder, takes up in its substance the arguments expanded upon in recently filed motions by the defence. In light of that, the Chamber reiterates what it said in its own decision 952. This decision was handed down yesterday, and we refer to that to formulate our decision. First, the Chamber reiterates, by referring to the case law handed down by the Appeals Chamber, that even though the instant motion is particularly tardy, it is disposed to address the merits regarding the exceptional circumstances that may warrant the tardy filing of such an application. As stated by the Chamber in paragraph 26 of its decision 952, the Chamber sees no reason why the defence would have been unable to file its motion at a preceding stage of the proceedings. My second point, the Chamber reiterates that the case file contains a number of examples demonstrating the fact that Defence Counsel could have received specific instructions from their client going to a significant number and a variety of matters, in particular his state of health. I here refer to paragraph 27 of the decision 952. Thirdly, the Chamber holds that the application, which implicitly refers to Rule 135 of the Rules of Procedure of Evidence, is tardy. As the Chamber stated in paragraph 29 of its 952 decision, let me quote from the English.
Defense request at this stage to discuss the present issue, the defense would in effect be forcing the Chamber to postpone the commencement of trial. The Chamber reiterates in the strongest possible terms that this Chamber will not permit such tactics to be used in the present trial proceedings. Fin de citation.
End of quote. For these reasons, and considering the submissions and information that has been placed before our Chamber, the trial chamber concludes that, as things stand, no adequate information has been made available to the Chamber to warrant a view that Mr. Alassane is unfit for trial. the Chamber will determine whether Mr. Al-Hassan understands the nature of the charges made against him. That said, the Chamber may order a medical assessment in keeping with the Rule 135 of the Rules of Procedure and Evidence. Accordingly, the Chamber instructs the Registry, in consultation with the parties, to make recommendations before the 24th of July 2020, going to experts who may undertake said medical assessment. The Chamber also instructs the parties to submit their submissions on the recommendations made by the Registry, and this at the latest by the 24th of July 2020. The Chamber will now turn to Mr. Al-Hassan to ask of him whether he understands the nature of the charges, the nature of each individual charge made against him. These charges having been read to him in closed session, and we seek from him a plea, innocent or guilty, under Article 64, paragraph 8 of the statute.
Claire, vous avez les décisions de la Chambre. Nous allons donc procéder.
So everything is crystal clear. You have the Chamber's decision, and we shall now continue with the entering of the plea. Count 1. Torture as a crime against humanity under Article 71F of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? The charge that has been, or charges that have been read to you whilst we were in closed session, that is.
Merci beaucoup.
Judge Mindua, thank you very much. Do you intend to plead guilty or not guilty to this charge? Or do you wish to remain silent?
الالتزام الصمت لا أستطيع الجواب عن هذا السؤال.
Merci beaucoup.
Thank you very much. The Chamber notes that at this stage of the proceedings, Mr. Al-Hassan intends to not enter a plea, either a guilty or not guilty plea to this charge.
Numéro 2.
Count 2. Mr. Duterte, I have not been able to hear the French or English translation, and in the transcript in English, we cannot see the interpretation of the accused answer unless I've made a mistake. Judge Mindua, Madam Courtroom Officer, please. The Courtroom Officer, I have been informed that there was an interpretation problem from English to Arabic. Could the interpreters please confirm to me that now everything is all right?
Monsieur le Président, tout est en ordre.
The Courtroom Officer, everything is fine. Judge Mindua, thank you very much. Mr. Prosecutor, we shall therefore move on to count 2, and you will ascertain whether everything is going all right, please. Count number 2. Other inhumane acts as a crime against humanity under Article 71K of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge? Answer, yes, I have indeed understood.
Merci beaucoup.
Judge Mindua, thank you very much. Mr. Anders Al-Hassan, do you intend to plead guilty or not guilty to this charge, or would you rather remain silent?
لا أستطيع الجواب على السؤال.
The accused, I cannot answer this question. I cannot answer this question. Judge Mindua, thank you very much. The chamber notes that at this stage of the proceedings, the accused has chosen not to enter a plea, whether as to admission of guilt or a plea of not guilty to this charge. Count 3, torture as a war crime under Article 82C1 of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge?
نعم فهمتها.
Mr. Al-Hassan, yes, I have indeed understood the nature of this charge. Judge Mindua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge, or do you prefer to remain silent?
لا أستطيع الجواب على هذا السؤال.
Mr. Al-Hassan, I cannot answer this question. Judge Mindua, thank you very much. The chamber notes that at this stage of the proceedings, the accused has chosen not to enter a plea, whether to an admission of guilt or not guilty. Count 4, cruel treatment as a war crime under Article 82C1 of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge?
نعم فهمتها.
The accused, yes, I have indeed understood the nature of this charge. Judge Mindua, very well. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge, or do you prefer to remain silent?
نعم لا أستطيع الجواب على هذا السؤال.
The accused, I cannot answer this question.
C'est-à-dire que vous voulez...
Judge Mindua, that means that you prefer to remain silent. Mr. Al-Hassan, yes, that is correct. Judge Mindua, the chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 5, outrages upon personal dignity as a war crime under Article 82C2 of the statute. Mr. Al-Hassan, can you confirm to the chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood, Judge Mindua. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge, or would you rather remain silent?
لا أستطيع الجواب على.
Mr. Al-Hassan, I cannot answer this question. Judge Mindua, very well. So once again, the chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 6. Passing of sentences without previous judgment pronounced by a regularly constituted court, affording all judicial guarantees which are generally acknowledged as indispensable under Article C4 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mandua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge, or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mandua, thank you very much. So you prefer to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 7. Directing attacks against protected objects as a war crime under Article 8(2)(e) little 4 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mandua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge, or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mandua, once again, you would prefer to remain silent. Thank you. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 8. Other inhumane acts in the form of forced marriage as a crime against humanity under Article 7(1)(k) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Mandua. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mandua. Once again, you would prefer to remain silent. Thank you very much. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 9. Sexual slavery as a crime against humanity under Article 7(1)(g) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Mandua, thank you very much, Mr. Al-Hassan. Do you intend to plead guilty or not guilty to this charge, or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question. Judge Mandua, so once again you prefer to remain silent. Thank you very much. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 10. Sexual slavery as a war crime under Article 8(2)(e) Roman figures 6 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Manjua, thank you very much. Mr. Al-Hassan, do you intend to now plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer that question. Judge Manjua, thank you very much. So once again, you prefer to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 11. Rape as a crime against humanity under Article 7(1)(g) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Manjua, thank you very much, Mr. Al-Hassan. Do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer this question, Judge Manjua. Thank you very much. You preferred to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Count 12. Rape as a war crime under Article 8(2)(e) Roman figures 6 of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have indeed understood. Judge Manjua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I could not answer that question. Judge Manjua, thank you very much. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. Persecution as a crime against humanity under Article 7(1)(h) of the statute. Mr. Al-Hassan, can you confirm to the Chamber that you have understood the nature of this charge? Mr. Al-Hassan, yes, I have understood. Judge Manjua, thank you very much. Mr. Al-Hassan, do you intend to plead guilty or not guilty to this charge? Or would you rather remain silent? Mr. Al-Hassan, I cannot answer that question. Judge Manjua, thank you very much. So you prefer to remain silent. The Chamber notes that at this stage of the proceedings, the accused has chosen to refrain from entering a plea of guilty or not guilty to this charge. You may be seated.
The Chamber now intends to make some observations of a procedural nature. The Chamber notes, firstly, that yesterday it received a defence filing entitled Notice of Affirmative Defence, document number 951, in which the defence informs the Chamber of its intention to raise grounds for excluding Mr. Al-Hassan's criminal responsibility, including the assertion that his conduct during the period of the crimes was allegedly coerced. The defence also alleges other grounds for excluding the criminal responsibility of the accused, such as mistake of fact or of law, under Article 32 of the statute, as well as superior orders under Article 33 of the statute. The Chamber takes due note thereof.
La Chambre entend ensuite
Intends to clarify that it is currently seized of a defence termination request to discontinue the proceedings against Mr. Al-Hassan. This is document number 885. The Chamber considered that, given the time limits in which this request was filed, less than 4 weeks before the start of trial, and the time deemed necessary for parties and participants to respond thereto, it was not possible to address this request prior to the commencement of the trial, nor did it consider it appropriate to suspend the commencement of trial in order to address this issue. The Chamber will therefore consider this request in parallel with the trial and in due course. Further, I recall that the Chamber set a deadline for the submission of any observation or objections by the prosecutor and the defence pursuant to Rule 1342 of the Rules of Procedure and Evidence. This deadline is set to the 1st of June 2020, and it was subsequently extended to the 10th of June 2020 following a defence request. In accordance with Rule 1342 of the rules, the Chamber is now asking the parties whether they wish to raise objections or make observations on the conduct of proceedings subsequent to the confirmation hearing, other than those they have already made. And those that they were not able to raise before the deadline set by the Chamber. In accordance with Rule 1342 of the regulations of the Court, such objections may not be raised in the proceedings without leave of the Chamber. Madam Prosecutor, you have the floor if you have any objections.
Mr. President, we do not have any objections.
Merci beaucoup, Madame la Procureure. Je me tourne.
Thank you very much, Madam Prosecutor. I now turn towards Counsel Taylor for the defence. Counsel.
Thank you very much, Mr. President. The defence has set out in its pleadings its objections to commencing the trial and substantive testimony before it has had an effective ability to investigate this case. Now, we have done so before the deadline, but we would also respectfully submit that this is an issue that will necessarily be impacted by the events as they arise. And that is reflected by the Chamber's own decisions, which have repeatedly stated that they remain seized of the possibility of receiving defence applications for adjournments depending on how circumstances unroll. So we would respectfully submit that the right to bring these types of objections under Rule 134, subsection 2, should not and cannot preclude the defence from seizing the Chamber in relation to specific investigative issues that we face, have faced, continue to face, and are likely to face before the commencement of testimony. And then that's not an issue that can be time barred, because once again, it depends on issues beyond our control, and it will depend on how things unroll with COVID and the security in Mali. Thank you.
Merci beaucoup, Maître.
Thank you very much, Counsel. The problem that you raise is one that was already resolved in the previous decision of the Chamber, and the Chamber is currently examining it. So you can be aware of that. The Chamber is not preventing you from addressing it when any issues should arise. I don't know if the prosecutor would like to intervene with regards to this statement of the defence. Thank you, Your Honour. Very briefly, just to say that the objections that have already been made can't be renewed ad infinitum. If there are new elements, then of course they can be raised. That is for the Chamber. But one cannot come back ad infinitum to the same questions.
Voilà, merci beaucoup.
That's it. Thank you, Prosecutor. Maître Taylor.
Very much one discrete clarification. We agree that we should not be able to relitigate issues. But when one is dealing with fairness, there's a threshold. And it's possible that the threshold for unfairness might not have been reached at one point in time, but the accumulation of prejudice, the accumulation of factors might bring us over that threshold. So for that reason, we are respectfully submitting that in future applications, we cannot divorce ourselves from what has happened up until this point. And we should be permitted to raise all of the issues in its entirety, so that in future applications, the Chamber is not dealing with things in a piecemeal manner, but is considering prejudice on the basis of the record as a whole and in relation to the threshold of fairness as a whole. Thank you.
Merci beaucoup.
Thank you very much, Counsel. I understand you very well. And I don't see any problem of fairness. The Chamber is doing its best to ensure it is up to the issue. But the problem is that when you present submissions, the Chamber decides, and sometimes you would seem to come back to the same subject in a new written submission. So you can also pay attention to that. Nevertheless, if you have any observations, you have until Monday, the 10th of 2020 to make them, and the parties and participants will have until Friday, the 21st of August 2020. So the Chamber takes good note of your observations and awaits your input. We are now going to hear the opening statements of the opposite Office of the Prosecutor. I note that yesterday the Chamber by email decided to reject the defence objections concerning the material that the prosecutor intends to use during its opening statements, and has given the prosecutor leave to use the material included in the list that it disclosed on the 6th of July in accordance with Annex A of Decision 788 9 on the conduct of proceedings, you have 4 hours, Madam Prosecutor. I would recall also that in accordance with Decision 867 of the Chamber, you have the possibility to ask that confidential elements in your presentation be only disseminated within the courtroom through a procedure that will make it possible for us to remain in open session. I would like you to indicate if you wish to avail yourself of this possibility and when, whilst recalling that recourse thereto must be as limited as far as possible and must only be for opening statements with a view to adherence to the principle of publicity of proceedings to the maximum degree.
Voilà. Donc, Madame la Prosecutor.
That's it, Prosecutor. Madam Prosecutor, you now have the floor, but once again, the Chamber reminds you, nevertheless, that the task of the interpreters and the court reporters will be far more simple if you would speak slowly, and yet more importantly, the presentations will be clearer and better understood by all who follow them or will follow them, whether that is here or outside this courtroom. And Madam Court Officer has the task of reminding us whenever it is necessary to do so. Madam Court Officer, nobody will take offence if you call us to order. From time to time, it is indeed incumbent upon you so to do. Madam Prosecutor, you have the floor.
President.
Thank you, President. Your Honour, your honours. Today marks the beginning of the long-awaited trial of the unimaginable crimes which have been committed in Mali. For almost a year, between April 2012 and January 2013, Timbuktu suffered from moral and physical violence meted out by the armed groups Ansar Din and Al-Qaeda in the Islamic Maghreb. Timbuktu, the pearl of the desert, where the population had been living in peace for years, was subject to their diktats. Timbuktu was subjected to their tyranny. As soon as they took the city, the members of Ansar Din and HAGUE created organs of control and repression. They created the Islamic court and the Islamic police, of which Al-Hassan was the key and zealous commissioner. In doing so, the members of these groups exercised a relentless grip on Timbuktu, its region, and the helpless civilian population. Their plan and design was to subjugate the men and women of Timbuktu to their power and control. Their plan and design was to impose their personal, religious, and ideological vision, and this by force, with a great deal of brutality and abuses constituting crimes against humanity and war crimes under the Rome Statute. This is at the heart of the present case: the use of violence, the commission of crimes against inhabitants who were belittled, humiliated, assaulted, and, to say it all, subject to a veritable persecution on religious and gender grounds, to which they saw no end, and in which Al-Hassan, the acting and thinking embodiment of the Islamic police, played a central role. Your Honour, Your Honours, I would like to clarify from the outset the following point. This case is in no way directed against Islam, nor is it directed against any religion or system of law or thought. It is simply a criminal case involving grave crimes. You have before you the case of a man, Al-Hassan, who, we will demonstrate beyond all reasonable doubt, is responsible for crimes under the Rome Statute committed against the inhabitants of Timbuktu and its region, crimes committed against Malians, against his own compatriots, no more, no less. It is for your court to show that individuals such as Al-Hassan cannot join armed groups of any kind, nor occupy part of a sovereign state that has chosen its system of government and impose, through force of arms and violence, on an entire population, precepts and prohibitions under the pretext of implementing their ideological and religious vision. This applies regardless of the ideas, regardless of the principles or religion one claims to follow. That applies irrespective of the rules that one allegedly wishes to apply. It is the very nature of the criminal acts and the pure violence against the civilian population that justifies the prosecution of Al-Hassan before your chamber. The variety of new prohibitions and rules were unmatched in the cruelty with which the institutions established by Ansar Din and Akim and the men such as Al-Hassan punished mercilessly the inhabitants of Timbuktu who were merely exercising their fundamental rights when they didn't bow to the new diktats. Your Honour, Your Honours, allow me to quote the words of an inhabitant of Timbuktu as they embody and summarise the pain and despair of the inhabitants. He says, and I quote, "The town has become a ghost town. Fear in the sense that all the population were hiding away in their houses out of fear of being punished, fear of being humiliated, fear of being brutalized, fear of being assaulted." The word fear is repeated on 4 occasions in this sentence. It is a leitmotif therein. It perfectly describes the calvary that the inhabitants of Timbuktu experienced on a daily basis during the entire occupation. You will see the example of Delio Maiga, who is unfortunately now deceased. He was bound to a chair in a public square before the entire population. His hand was amputated in the most brutal way possible with a type of long knife. Who found him guilty? The irregularly constituted Islamic court established by Ansar Din and Akim in Timbuktu to give a semblance of legitimacy to their tyrannical regime. His life was turned upside down. As far as he was concerned, his life was over. The purpose of this punishment was twofold. Firstly, to demonstrate that there was no limit to the power of armed groups in Timbuktu, to demonstrate that nobody could oppose them, even when they committed the most extreme and violent acts, and with good reasons. Ansar-Din and Akim held all the weapons. And secondly, they wanted to make an example, to strike fear into people, to spread terror, and thus further subjugate and coerce the population into obeying the new rules and prohibitions. And who do you imagine arrested, did you? It was Al-Hassan himself. You'll see today Al-Hassan in a video. He totally sanctions this criminal and brutal mutilation. In fact, as my office will prove, Al-Hassan was directly involved in the violence and torture inflicted upon the population, on the men, the women, and the children of Timbuktu. As a commissioner, he held a central function. He worked in a proactive way within the heart of an oppressive, repressive, and persecuting system in which the crimes in this present case were committed. The evidence will show that Al-Hassan led the organization, the management, and was responsible for the functioning of the Islamic police, that Al-Hassan arrested and detained persons, that Al-Hassan conducted investigations on alleged violations of rules imposed by the groups, during which suspects were tortured and threatened in order to obtain confessions, that Al-Hassan referred cases to the Islamic court, that Al-Hassan participated personally in the meting out of corporal punishments by the police, and those decided on by the irregularly constituted Islamic court. And this was done in public or at the headquarters of the Islamic police. Having stated that Al-Hassan worked with the armed groups Ansar-Din and Acme during the entire occupation of Timbuktu, the very day of the arrival of these groups in Timbuktu, the start of April 2012, a witness saw Al-Hassan and members of the armed groups at the bank, which was soon going to become the headquarters of the Islamic police. We have the evidence that he investigated and wrote at least one police report in a case which was among those heard by the Islamic court during its session of the 7th of May 2012. He remained the commissioner of the Islamic police, a veritable pillar of that organ, until the departure of the armed groups from Timbuktu in January 2013. If you would allow me, Your Honour, to now speak in English.
I will now continue my statement in English. Mr. President, Your Honours, Ansar-Din and Acme are still active in Mali and Timbuktu region. They pose a grave danger to the safety of witnesses and victims. I shall therefore not go into specific detail here. You have them in the confidential version of the trial brief and other filings. The people of Timbuktu themselves know full well what I'm alluding to. because they have experienced these crimes and suffered physical and mental anguish as a result of them. The evidence of the prosecution will demonstrate that as the armed groups arrive, civilians fled to Bamako or other southern cities, as well as to neighboring countries such as Mauritania or Burkina Faso. They had to leave everything behind. They had to leave their lives behind. Many left to escape the violence, but others remained for one reason or another. Some stayed behind because they simply did not have the means to flee. Others because they had elderly parents to take care of. And others still because they felt attached and responsible for their city or could not resign themselves to abandoning their beloved Timbuktu, especially during one of the worst moments of his history. Those who remained were subjected to a constant climate of fear and oppression. The members of Ansar Din and Akim made sure of that, continually strutting about with their weapons. In videos, they are publicly available. One can readily see the Islamic police weapons. One can see the judges' weapons next to them during sessions of the tribunal. One would indeed see weapons everywhere, all the time, and that includes heavy weapons mounted on pickup trucks driving around the city. The reign of terror was in place and its tools of enforcement on full display. In this state of occupation and coercion, the Ansar Din and Akim's members severely restricted. They monitored and controlled everything. A Timbuktu local stated at the time, and I quote, "In Timbuktu, everything has become illicit and forbidden." And another one pointed out that everything was under the control of the armed groups. All aspects of life had indeed fallen under Ansar Din's and Akim's self-proclaimed rules and prohibitions. Drastic restrictions were imposed on private life, public life, leisure activities, cultural and religious practices, the manner of praying. This affected absolutely everything, even the way inhabitants could or could not dress. Not only were these rules new, but they were also quite alien to the residents of Timbuktu. These imposed rules also denied many customs, traditions, and social practices of the inhabitants, which had characterized the lives of locals in Timbuktu, sometimes for generations. They constituted severe and serious violations of their fundamental rights, such as the right to religion, to private life, or to education. And here I would like to present a brief overview of these rules to demonstrate their breadth and scope. Banning religious practices at the tombs and mausoleums of Muslim saints. Prohibiting celebrations such as the celebration of Maulud. Banning amulets and talismans. Prohibiting statements, masks, and pictorial representations. Complete control over the media, including radio. Banning public gatherings. Closing public schools. Banning music and dancing. Segregating the sexes, including at school. Imposing a new dress code on men, and particularly on women. Men needed to shorten their trousers, and women were required to cover their bodies head to toe. A normal veil was not enough. And in that same vein, banning women from wearing jewelry and makeup, even their traditional clothing was denied to them. The list is long, and I could go on. The control and domination was total. It was a complete change in the way of life of the inhabitants, as many witnesses will testify. Worse still, any disobedience would result in severe and cruel punishment. In the event of a breach of the new rules, corporal punishment would be applied on the spot by the Islamic police, generally in the form of lashes by a whip. You will see some examples of such measures during the prosecution's presentation of the case. Punishments, including floggings, up to 100 lashes, amputation, and imprisonment, were also executed following decisions by the irregularly constituted Islamic Tribunal. Al-Hassan himself pointed out during his interview with our investigators, and I quote, "The residents were not familiar with this punishment. It was the first time that they had seen that. They were scared out of their minds. They couldn't do anything. Everyone was afraid and feared the words of jihadists and terrorists. They were scared of this punishment." Al-Hassan said this. Clearly, Mr. President, Al-Hassan was well aware and indeed involved, as the evidence will show, in this cruel and brutal repression. A witness will testify that it is the Islamic police that was often in charge of organizing executions of sentences, and that he often saw Al-Hassan in charge of them. And this witness will further testify that there was not a single event of execution of sentence in Timbuktu that he attended where Al-Hassan was not present. As a result, Mr. President, it is no surprise if 1,000 kilometers to the south, in Bamako, a witness heard about Al-Hassan. And this witness stated, "Lots of people who fled to Bamako spoke about Al-Hassan and the Islamic police." Mr. President, Your Honors, the prosecutor's evidence will demonstrate that the multiple acts perpetrated against the inhabitants of Timbuktu and its region constituted a real attack against the civilian population. Sentences handed down by an irregularly constituted tribunal, sentences without prior judicial proceedings, torture, cruel treatment, other inhumane acts, outrages upon personal dignity, sexual slavery, acts of rape, attack against historic monuments and buildings dedicated to religion, amongst other offenses. And these are all grave acts and crimes under the Rome Statute which, when taken in their totality, fit the characterization of the crime of persecution, which is also specifically addressed in the Rome Statute. There was religious persecution in Timbuktu. All the rules and prohibitions imposed on the residents stemmed from the ideological and purported religious vision of Ansar Din and Akim. My office has pledged to systematically fight impunity for gender-based crimes where the evidence supports such heinous crimes. In the present case, gender-based persecution was yet another manifestation of this rule by force and terror. Indeed, it was the women and girls of Timbuktu and the region who were targeted and suffered the most. Our evidence will show that women had become the primary targets. Women and girls were pursued into their very homes. They were abused, punished, beaten, imprisoned, and subjected to corporal punishment for a variety of so-called breaches, from failure to wear the prescribed clothing, giving water to a man, not having gloves at the market to pay and receive money, amongst others. And with your indulgence, I would like to briefly touch upon the prison conditions which added to the suffering inflicted on women. The evidence will show that women were kept in inhumane conditions in a room, a small room, at the Bank Malian de Solidarité, which residents dubbed the women's nightmare cell. It was a 2 square meter room housing the ATM, And we will show you this infamous cell so that you can see for yourself what these women endured. Women were locked up in a makeshift cell and treated shamefully. At times, not one, but several women were kept in confinement in that limited space, and all this took place in oppressive heat. Some had no option but to relieve themselves in that cell. Our evidence will also show the extreme degree of violence experienced by the women who were subjected to floggings. Al-Hassan knows what I am talking about. He himself was personally involved in organizing the infliction of corporal punishment in public on women accused of adultery. He can be seen on video or photographic material. Some of the details are unbearable and particularly horrid. I am thinking, for instance, of a woman who fell to the ground under the sheer violence and force of the blows. Another woman, punished with 100 lashes, stated, and I quote, "J'ai ressenti beaucoup la douleur physique."
I felt the physical pain. I couldn't. Birth on my back. I had marks on my body. There were red marks, and the blood had coagulated on my skin.
Present when this flogging was handed down and executed. But there was an additional level to the horror. I am referring to all the sexual violence the women and girls, sometimes very young, were subjected to. As our evidence will show, a system of marriage was put in place, mainly intended to enable the members of the armed group to satisfy their sexual desires and needs at the expense of the women and girls. Many were hence forced into marriage, confined against their will, and repeatedly raped by one or more members of these armed groups. All that was left of me was a corpse. This is how one victim recounted her ordeal. It should be noted that these women and girls and their families had no choice. Evidence will show that some of the leaders of Ansar Din and Akim, including Al-Hassan, assisted members of the Islamic police to enter into these so-called marriages or participated in marriage negotiations, de facto exerting pressure on families and women through their presence and influence. Overall, the targeting and persecution of women was such that it became emblematic of the physical and moral violence inflicted on all residents of Timbuktu. Mr. President, Your Honors, the victimization of the population, women and men, was significant, and the case before you against Al-Hassan is extremely serious. The prosecution has gathered a wealth of evidence, and this evidence will show that the reign of terror imposed on the inhabitants of Timbuktu during the period of occupation by Ansar Din and Akim groups was without precedent in modern history of Mali and of the people of Timbuktu. The residents of Timbuktu, men and women alike, were relentlessly tyrannized on a daily basis over a period of 10 months. The evidence will also show that Al-Hassan, who perfectly knew the Timbuktu region and the local languages, was a key figure within the armed groups and played a key role in the system put in place to control the city and the region. The unassailable facts in this case point to his guilt and responsibility for all the crimes charged. Al-Hassan was engaging in such conduct unreservedly and with determination. In the evidence that the prosecution will present at this trial, you will see Al-Hassan giving interviews, approving and supporting the policy of the armed groups. You will see him parading with his Kalashnikov and then take a victim to the place where he was executed. Al-Hassan was clearly acting out of his free will. And all of this is corroborated by Al-Hassan's own statement during the interview conducted by representatives of my office in the presence of a lawyer who assisted him and an Article 56 counsel appointed by a judge of this court. Mr. President, Your Honors, back in 2016, Mr. Al-Mahdi was convicted for attacks against religious and historic monuments in Timbuktu. Today, the case against Mr. Al-Hassan is before you with a wider spectrum of crimes. This case represents the continued efforts by my office to bring justice to the people of Timbuktu and Mali, more broadly, who fell victim to those heinous crimes. The suffering endured by Timbuktu and its inhabitants is emblematic of what happened in Mali and the conflict that continues to create misery and suffering in that country. The importance of this trial to the victims of Mali in general cannot be overemphasized. Serious crimes under international law cannot go unpunished. It sends a clear message to all the parties to the conflict operating on the ground in Mali that those responsible for serious violations will be held accountable. Mali deserves justice. The victims of the accused crimes deserve justice. And this court has the opportunity to make an important and tangible contribution to that need and yearning. This trial does not operate in a vacuum. As we embark on this trial, Mr. President, the situation in the center of Mali, but also the rising tensions and related instability and violent incidents in Bamako remain a great concern to my office. All the parties involved must refrain from resorting to violence. The specific and general deterrence of this case is to be appreciated in this larger context. Mali and Malians have suffered immensely. They deserve to have this court on their side. They deserve to have justice done and see that it is done. The ICC stands as a last beacon of hope to those looking to it for justice for the world's gravest crimes. And we must deliver on that promise and indeed that obligation. Mr. President, Your Honors, I thank you for your attention, and I will now hand the floor over to my learned colleague, the senior trial lawyer in this case, Mr. Jules Dutertre, who will present the context in which the crimes in question were allegedly committed with a more detailed outline of the evidence supporting the charges. Mr. President, Your Honors, I thank you.
Presiding Judge, my thanks, Madam Prosecutor, specifically so because you made some of your submissions in French and the remainder of your submissions in English. I think we're meeting with a small logistical problem, one of house management, if I can put it that way, because unless I'm mistaken, we began at 1:45. Now we have to do an hour and a half as a block session, so we now need to go on to an adjournment of 45 minutes. Is that right, Madam Court Officer? She nods her head in agreement. So this is what we're going to do. Before asking Mr. Dutertre to rise, we shall have an adjournment of 45 minutes before resuming. The hearing is adjourned.
All rise. Veuillez vous lever.
Presiding Judge. The hearing rather, is in session. Good morning, good afternoon rather, to one and all. To resume the opening of the prosecution. Over to you, sir. Mr. Duterte. My thanks, Your Honour, honourable members of the bench. A small point. I'll be using 5 slides from a PowerPoint presentation, so in due course I'll be asking of the court officer to give me leave to switch on to evidence 2, in all likelihood, to disseminate this public material. Court officer, evidence 2 has indeed been allocated to you, counsel.
C'est parfait.
Presiding Judge, please continue, counsel. Prosecution, my thanks, Your Honour. Your Honour, honourable members of the bench, Alassane is before you today for one single reason. His was a pivotal role in the oppression to which the Timbuktu population was made victim from the entire period from April 2012 through to January 2013. He was key to the repressive system established by Ansar Din and ACME in and around the city. He actively participated in the commission of war crimes and crimes against humanity inflicted on its inhabitants. And by crimes, I notably refer to torture, inhumane acts, as well as persecution on religious grounds and persecution directed against women and young girls. The hard reality is that Al-Hassan was the commissioner of the Islamic police. That very Islamic police was itself one of the principal organs of the system of control established by Ansar Din and ACME to bring the Timbuktu men, women, girls and boys under their power. That police was in the vanguard to control and monitor, repress, sanction and arrest the inhabitants and have them submit to both their dictates and prohibitions through violent and brutal physical punishment. Alassane was the driving force within the Islamic police during the occupation. True, there was an emir appointed to the Islamic police, Adama, followed by Khaled Abu Suleiman. But Alassane held a vital role in the assignments and operations of said police. It was he who ran the police on a daily basis. It was he who played a major role in the police's interactions with the other organs of the repressive apparatus, particularly with regard to the irregularly constituted Islamic court. First and foremost, it must be said, within this ambit, Al-Hassan was a direct perpetrator and contributed to the commission of other crimes he is charged with. I shall soon address you on that matter, Your Honours, honourable member of the bench, but to better understand the backdrop against which Al-Hassan committed these crimes, Allow me first to return you to those few weeks and months prior to Timbuktu's fall into the hands of the armed groups Ansar Dine and HAGUE. It is 2011. The world watches as Colonel Gaddafi falls. Many armed groups in the sub-region use this opportunity to better equip their military arsenal thanks to the looting of Libyan arms dumps and the weapons trafficking that it triggered. One such group was HAGUE, a very well-known terrorist group. Another was Ansar Dine, a Malian armed group formed at the end of 2011 to defend, as they claimed, religion. In this context, the 17th of January 2012, the National Movement for the Liberation of Azawad launched an attack on the Menaka military camp in northeast Mali. This sparked an armed conflict of a non-international nature on Mali's soil. Clashes began to multiply, particularly in Agolok and Tessalit. Within 3 months, the northeast of Mali, making up 2/3 of its national territory, passed under the total control of the armed groups, and especially that of Ansar Dine, HAGUE, and the Movement for Unification and Jihad in West Africa, otherwise known as Mujal. Kidal fell on 30th of March 2012 to Ansar Dine. Gao fell on 31st of March 2012 under the control of the MNLA, quickly evinced by Munjao. The following day, the 1st of April 2012, Timbuktu, a major city in West Africa, falls into the hands of Ansar Dine and HAGUE. Everyone will recall pictures of pickups bristling with black flags and heavy weapons rising from nowhere out of the desert and parading in triumph in the streets of Timbuktu. An easy victory, it must be said, since the Malian army, traumatized and terrorized by the bloody massacre of prisoners of war at Agolok, had abandoned the city. The reign of Ansar Dine and HAGUE would hold sway until January 2013, when they were ultimately dislodged, particularly by members of Operation Serval. With your leave, Your Honours, at this juncture of my submissions, I would like to refer you to screenshots. There you have it, a first screenshot, which shows us the armed groups in Timbuktu. Behind, we can see the Shekabeh Grand Mosque. You picked that out in the background, Your Honours. And on the subsequent screenshot, what do we see? We see the type of military equipment that these groups could use in Timbuktu. This is what inhabitants of Timbuktu were up against. This gives you an inkling into what we're dealing with here, honourable members of the bench. Ansar Dine and HAGUE, Your Honours, made no secret whatsoever of their intentions and objectives once they had entered the city of Timbuktu. As soon as the city fell, Iyad Ag-Khali, founder and leader of Ansar Dine, I've already mentioned that, immediately announced that he was now the city's new master. He stated that his organisation henceforth represented the public authority and the law. Iyad Ag-Khali made clear, above all, that any conduct infringing their rules would be punished, and that the offenders would have, I quote, problems with him and his group, end of quote. This comes through the witness P0125, Your Honours. In parallel, the words of Sander Oud Boumama, Ansar Dine spokesman, are unambiguous regarding what Ihad Ag-Khali understood by problems, in inverted commas. Sander says in Timbuktu, and here I quote, "I know we shall be cutting off hands. We shall also be cutting off heads if the Sharia stipulates so. We have no qualms about that." End of quote. The members of Ansar Dine and ACME in Timbuktu are therefore clearly guided by a common plan, a common objective. Their objective is to cement their power and control of the city, its environs, and the civilian population, and to impose their personal, ideological and religious views on said civilian population. And this by all means possible, Your Honours, including conduct, acts and measures which, in the normal course, resulted in serious breaches of the fundamental rights of the inhabitants and in the commission of acts of violence and crimes charged in the instant case. To fulfill their ends, Ansar Dine and ACME swiftly established in Timbuktu organs for decision-making, control and repression. At the top of the hierarchy, we have the emirate, or the presidency. It comprised three individuals, Abu Zaid, Yayu Abu al-Haman and Abdallah al-Chingeti. Abu Zaid, an Algerian. He was a very long-standing member of ACME and battalion commander, Tariq ibn Zayed. Ibak Ag-Khali introduced him as the new governor of Timbuktu. Yahya Abu al-Aman, also an Algerian, head of ACME's Al-Furqan battalion. He would later become ACME's emir for the Sahel as a whole. And lastly, Abdallah al-Chingeti from Mauritania. He was a spiritual leader, member of ACME's Al-Furqan battalion, and he would eventually become its commander. These three individuals, Your Honours, are now all deceased, but in 2012 they comprised the presidency. The presidency ran the city on a daily basis, while Ihad Ag-Khali, often from his base in Kidal, retained control over what was happening in Timbuktu, particularly through his regular visits on site. Below the presidency, Your Honours, we find various organs, including the Islamic Court, the Hezbollah, also called the Vice Squad, the security battalions, the media office, the religious committee, the training centres, and above all, for our purposes, the Islamic police, first housed in the Mali Solidarity Bank, called BMS, and then in the governor's office. The court will hear evidence giving you detailed insight into all these institutions that we referred to as organs in our pre-trial brief. Taken together with the armed groups Ansar Dine and ACME in Timbuktu, we have what it can be described as the organisation. New institutions, therefore, Your Honours, in a word, responsible for imposing by force the public authorities' power and the religious ideology of Ansar Dine and ACME, but with the essential assistance from local people. Indeed, Ansar Dine and ACME, largely made up of foreigners and non-natives of Timbuktu, take care in appointing to these organs the few members in their ranks who are indeed native to that region. They needed them. Their goal was to lend local colour to their work. Their goal was also to be fully operational through people who had sound knowledge of the place, the region, their inhabitants and their languages. Hence, Huka as de facto president of the Islamic Court. Hence, Al-Mahdi and Mohammed Musa as each in turn leaders of the Hezbollah. Hence, Abu Tala, who leads the security battalion. Hence, Sander Ould Boumana acted as a spokesman for the groups. Hence, also, Al-Hassan, who became the Islamic Police Commissioner.
All of these people are native to Timbuktu and its region. Most are, for that matter, from the very same tribe as the accused. All these people, including Alassane, are members of the common plan and adhere to the common goal of these groups. Within this context, Your Honours, it's crucial to understand three things. First, these organs work in close conjunction, particularly the Islamic Court, the Islamic Police and the Hezbollah. These were demonstrably the three most active organs in the persecution of the local population. Second, I reiterate, the Islamic Police was itself the most heavily deployed organ on the ground and the most involved in the repressive apparatus. Third, Alassane, as commissioner, held a pivotal role. I move to illustrate, using examples, how these organs coordinated amongst each other. This coordination was sought by so-called Governor Abu Zaid. He gave instructions on 15th of August 2012 regarding how to react in cases of infringement by the local population of the new rules and prohibitions. He addressed these instructions to all, to the Islamic police officers, to members of the Hezbollah, and more broadly to all the members of the armed groups. The message was clear. It was a collective enterprise. Everyone was involved to make sure that these dictates and prohibitions were properly abided by. This coordination was translated into practice on the ground through various ways. The accused, for example, stated that the police assisted the Hezbollah in patrols and that sometimes they patrolled in unison. It was notably during these patrols that local people were arrested. Indeed, once arrested, the person was, in the vast majority of cases, questioned by the police, who then drew up a report and referred the case as appropriate to the Islamic Court. This latter entered a conviction on the basis of said report. Punishment was therefore meted out particularly by the police. In point of fact, Alassane lay at the heart of this apparatus. My learned friends Diane Looping and Musa Alafi will expand on that point further, Your Honours, for it perfectly illustrates the linkage between the Islamic police on the one hand and the Islamic court on the other, as well as the substantial contribution of Alassane in this regard. A brief parenthesis, Your Honours, which echoes what the prosecutor mentioned this morning. This court goes by the name the Islamic Court, in inverted commas. This name was in fact given by the armed groups themselves. Here I make no criticism of Islamic courts that may exist elsewhere. What is here being prosecuted in the instant case, Your Honours, is the manner in which these armed groups, Ansar Dine and Acme, established that court and the manner in which it operated on the ground. That tribunal provided no guarantee of impartiality whatsoever, Your Honours. Abdullah al-Chingeti, a member of the presidency, I've always made mention of him, in other words, the executive branch, if you will, sat on that court and wielded very considerable influence. That tribunal in no way, in no shape or form, complied with the most basic procedural guarantees. It approved, for example, the use of torture as a method of questioning. It is, put simply, an irregularly constituted tribunal. No more, no less. I end my parenthesis, Your Honours, and I return to the cooperation between the organs. Within this tight collaboration, the evidence will show that the Islamic police had a prominent role, held a privileged position. This must be recognised. This reading flows from numerous non-exhaustive aspects. The Islamic police was the first organ to be established. After being housed on the BMS's premises, the police moved to the governor's office building. This move is very telling. It is symbolically significant. Compare with the Islamic court, which operated at a hotel or in a private house. The police had more staff than the Hezbollah. witness 0122 specifies that it was more than 30 members strong, whilst the Hezbollah only had 10 members, according to another witness. The police was also heavily equipped with weapons, unlike the Hezbollah, whose members went mostly unarmed, hence the joint patrols. This information comes directly to us from the accused himself, Your Honours. The police also had vehicles and motorbikes, and here again we know that the Hezbollah was less well equipped. This comes from the statements of an insider. The police was omnipresent. It affected patrols everywhere in Timbuktu and its environs, armed with Kalashnikovs and whips with which to beat civilians. This you will see in video material as the trial unfolds. They even travelled as far as Kabara, Lear and Gundam, hundreds of kilometres away from Timbuktu. The police officers were basically everywhere, in the street, in the market, in the schools, and even in inhabitants' private dwellings. And this night and day. It was also the police which was, as a point of principle, responsible for making arrests. Mr. Al-Hassan specifies that if the Hezbollah encountered anyone violating the rules, the Hezbollah was rule-bound to call the police, who would then go to the place in question, make the arrest and take the offender into custody. It was the police who questioned and drew up reports. The proof is in the pudding. We've found more than 70 police reports and only 2 authored by the Hezbollah, Your Honours. The police also responsible for meting out punishments and managing the prison. A non-exhaustive list, Your Honours, of the preeminence of that organ. I spoke of weapons and ammunition, but images and pictures are sometimes more eloquent than words. So I refer you to these police patrols and what they look like through 3 screenshots, Your Honours. If the computer wishes to play ball. On this first screenshot, we see 2 members of the police force patrolling with their vehicles, following with a police officer on his motorbike. Here, you can see they are armed with weapons of war. We can see a Kalashnikov, which is just poking up above the left shoulder of the police officer to the left of your screen, Your Honour. We also see their blue vest, where we see Islamic police written on it. And on another screenshot, Your Honours, what we see is that the ammunition that they carried with them are war weapon ammunition. This is what applied law in Timbuktu upon the inhabitants in the day, Your Honours. This is what was travelling around the Timbuktu roads and streets. Within this ambit, Your Honours, Mr. Al-Hassan himself played a major role within the Islamic police. We know that the accused did indeed join the ranks of Ansar Din. The evidence will bear this out. He even confirmed it himself, Your Honours. However, he joined much earlier than he in fact claims. Madam Prosecutor has raised this point. My learned friend Diane Luping will revisit this point in detail. Very quickly, Al-Hassan became the linchpin within the Islamic police. At the time, in Timbuktu, the inhabitants knew that he was the commissioner. The members of the armed groups saw him as such. He also acts as such, Your Honours. And years after the material time, he confirmed to witness P0605 that he was the commissioner. So he became Islamic police commissioner, a police force set up by Acme and Ansar Din. He became so because he espoused these groups' views, Your Honours. And these are terrorist groups. Such groups don't hand out willy-nilly such a position of responsibility, such as police commissioner of an entire city under their total control. To be so appointed, they must know you and trust you implicitly. Additionally, the evidence that you shall hear throughout the trial will leave no doubt whatsoever that Mr. Alassane agreed to the common plan and the common goal, which clearly existed as soon as the city fell to their control. This emerges, as you will see, through his acts and conduct during the material time. This emerges from what he said in Timbuktu in 2012, and we have recordings of what he said. This emerges, for example, from the quantum of telephone calls between Alassane and the other members of the common plan. You will hear experts address you on this matter, P0587 and P0617, who will be addressing this matter in their expert evidence, Your Honour. Not only did Mr. Alassane join the common plan and goal, he was among the core members who on a daily basis sustained it. He wasn't the governor of Timbuktu. He wasn't the emir of ACME for the Sahel. But in the city and even beyond its walls, he belonged to those essential people in a position of responsibility, Your Honours, who sustained day in, day out the common plan, who sustained the common goal throughout the 10 months occupation of Timbuktu. And you'll see on a video, for example, you'll see him doing his work, giving instructions to patrolling police officers at Liri, very far away from Timbuktu. I move now to acts of violence and abuses, Your Honours. They were often, they were held in public. This was a typical feature of the modus operandi and the objectives of the organisation at Timbuktu. An example, the first flogging. It took place on the 20th of June 2012 on the main central Sankori Square. A couple was whipped for what the group saw as an instance of adultery. The entire population was marshalled onto the square. It was an opportunity for Ansar Dine and ACME to flex their muscles, to offer their first example of public punishment, to imprint it on people's minds, to intimidate and more broadly to terrorise. Everything was put on film. We see clearly on these videos that the inhabitants do not rejoice at this cruel spectacle. Consequently, its violence was twofold. It was physical and psychological for its two unfortunate victims who suffered pain and everlasting shame. It was also psychological for the entire population who was subjected to this pitiful sight, which flew in the face of their values and way of life. When you see your wife, when you see your daughter, when you see your mother beaten, and you can do absolutely nothing to stop it, you are yourself humiliated, belittled, diminished. The entire population, made powerless, was collectively humiliated, trodden underfoot in the face of heavily armed tormentors against whom they could try nothing, attempt nothing, do nothing, Your Honours. On the 20th of June 2012, the message was abundantly clear. Any violation of the rules would unleash a merciless response. The inhabitants lived, therefore, for several long months with a nagging fear that they themselves may become physical victims. From June the 20th, 2012, public punishment and acts of violence grew in number. The local population didn't feel that Ansar Dine and ACME sought to make them better people, not at all. The population, essentially Muslim, had seen that their fundamental rights were being trampled underfoot and seriously prejudiced. They saw themselves as targeted, attacked, persecuted, victims of a systematic widespread attack. This is what makes this case so very serious. Madam Prosecutor has given you one or two examples of violence, but the police could stop you in the street and punish you on the spot. Women were brutalized on the spot, forced marriage, even rapes, and children suffered rapes. They were called children of the ICC for want of an identifiable father. The list of criminal acts committed during this reign of tyranny is long. In a YouTube video, an inhabitant from Timbuktu, this dates back to the 30th of June 2012, I quote, "Timbuktu is on the brink of losing its soul. Timbuktu is under peril of outrage and ruin. Timbuktu sees held against its throat the razor-edged blade of cold-blooded murder." End of quote. Timbuktu went through a terrible period. This is the things that they had to face, Your Honours. Your Honours, Alassane must be held responsible for the alleged crimes. The prosecution shall prove his responsibility beyond reasonable doubt for either his personal and direct commission of the crimes, where he appears, for example, on film flogging poor victims in public and inflicting on them intense pain, or that he contributed to the commission of said crimes by, for example, supplying the irregularly constituted Islamic court with the reports on the basis of which punishment was ordered. More generally, the evidence will show that Alassane contributed in manifold ways to the commission of crimes by the group involved in the common plan and that should be held criminally responsible, Your Honours. The prosecution has a vast body of evidence. We have videos depicting Alassane in action. We have police reports written and signed by the accused. We have judgments returned by the Islamic court signed by HAGUE. We have witness statements, Your Honours. We have victim statements. We have insider statements. And reams of medical expertise, ballistic experts' reports, experts addressing authenticity of documents, experts on handwriting and signatures, expertise on voice identification, an expert's report on facial identification, an expert in telephone data on satellite imagery. This entire body of evidence will be placed before you as the trial unfolds, Your Honours. Of course, we shall have to factor in the COVID pandemic. The prosecution cannot call witnesses in the order we would have liked in order to present the evidence in a coherent and organised fashion. We had to prioritise travel requirements and ability to travel. But all in all, Your Honours, the prosecution will ultimately prove beyond a reasonable doubt the crimes committed and the criminal responsibility of the accused in their commission. Your Honour, honourable members of the bench, the inhabitants of Timbuktu thirst for justice. They seek to drink to the lees the warm and soothing milk of truth. They are pinning every hope on the judgment that you will be rendering at the close of this trial, Your Honours. I now give way to Diane Looping, my learned friend, who will enter into the finer detail of the abuses and conducts of Mr. Alassane within the Islamic police. I thank you, Your Honour. Presiding Judge, thank you very much, Mr. Prosecutor Duterte. I now hand over to Ms. Looping. You have the floor, Counsel.
Good afternoon, Mr. President, Your Honours. I'll be addressing the topic of Mr. Al-Hassan's role and functions within the organisation. Just a technical point for information of the court officer. All of the slides that I'll be presenting may be broadcast publicly, and I would ask if I could please be given the floor to present the slides already.
You have the floor, Ms. Looping.
Thank you, Court Officer. Your Honours, as the de facto commissaire of the Islamic Police, Al-Hassan was a key player, a key implementer and enforcer of the organisation's power and its rules. What was his role? Well, he was responsible for the daily management, organisation and work of the police, as well as for the investigations and prosecutions of numerous cases against civilians for violations of the organisation's imposed new rules. And what was his impact? All of his acts and conduct had an impact on nearly every aspect of the local population's lives and contributed to the crimes committed against them. His work supported the coercive and persecutory environment in Timbuktu. Your Honours, I will address 3 key points. First, Al-Hassan's impact as the key face and interface of the police with the local population. Secondly, the intentional, voluntary nature of the work that he did and the timing of when he carried out that work. And third, his core functions. First, in terms of Al-Hassan's impact on the local population, they had no choice but to engage with him. In his role and exercise of his functions, he was the key face, the key interface of the police with the local population. In particular, Al-Hassan actively imposed the rules on the local population during his patrols, at the police headquarters, during his investigations of the many cases of violations of their rules, and in civil disputes, during his arrests, summons, detention, and interrogations of individuals who were subjected to violence, torture, and severe sanctions. In the cases that he referred to the Islamic Tribunal, when he brought suspects to the tribunal, when he executed punishments against them, he was the leader writing and signing police investigation reports concerning the people, and he could sign permits issued to them affecting different aspects of their daily lives. His reports on cases involving the population had an impact on the tribunal judgments as the judges relied on his reports. Al-Hassan was the person that the local population consistently saw in their mediations and disputes. The groups chose Al-Hassan to be a spokesman during interviews, to spread their propaganda, supporting the organisation in imposing their own rules, their punishment against the local population. Al-Hassan also acted on behalf of his men in their personal interactions with the local population, in so-called marriage negotiations, and in requesting dowries on their behalf. And it was Al-Hassan's personal phone number displayed on the Islamic Police Headquarters sign for people to call. Sorry, Your Honours, just one moment, please. I have to ask for a court officer's assistance, as there seems to be a technical problem with these slides. I'm having to do it manually. It seems to be working now, Your Honours. So if we just turn to the first slide, we have the facade of the Islamic police. And in the red box, you will be able to see the accused's phone number. It's the very first number on the sign. And you will hear evidence. You will see call data records. And there is also the evidence from the accused himself confirming that this was the accused's number and that this sign hung from the police headquarters from April 2012. Al-Hassan was at the very heart of this repressive system, and he was involved at different stages of its functioning. Al-Hassan's role and his functions as the de facto commissaire and key interface with the population was common knowledge in Timbuktu. You will hear witnesses confirm this, including those who knew him well. You'll hear from victims and eyewitnesses, journalists and insiders alike. And Al-Hassan introduced himself as the commissaire, or the person responsible for the police, to individuals, such as witnesses P113, P984, P605, and journalist 623. One witness, a former member of the Islamic police, and one of Al-Hassan's subordinates explained, and I quote, and this is in French, "La police
The police there. The person in charge is the commissioner. Everything that's done at the police, the person in charge is the commissioner."
And I quote, again in French, "Mon rôle, c'est..."
My role is the role of the police.
Al-Hassan was a logical choice for the groups. He was the right man at the right place at the right time. He came from Timbuktu, so he was well known to the local population. He spoke their local languages as well as French and Arabic. He was an educated man. He was a Tuareg and a member of the influential Kel Ansar tribe. He was trusted by the other leaders as he shared their ideological, religious, and political views. He had regular access to the senior leadership, and he was in constant communication with them, and they entrusted responsibilities to him. The organization's target was the civilian population of Timbuktu region, and the many victims of this case whom Al-Hassan's contributions have impacted upon included, for example, women and girls arrested for their dress code violations, who were then detained in harsh and inhumane conditions, many of whom were subjected to sexual violence. Jadeo Maiga, whom you heard, Al-Hassan himself arrested, whose hand was then publicly amputated following a judgment of the tribunal. You'll hear evidence from P580, also arrested by Mr. Al-Hassan, who was severely beaten, tortured, and illegally detained, and victims whom the accused flogged for drinking alcohol. Al-Hassan was a willing perpetrator and member of this organization from the very outset, who believed in their vision, their shared ideology, religious and political vision of the organization, which they invoked to impose their power and their rules. He fully embraced his role and functions within the police in enforcing these new rules on the population and to impose their power from the early days of the occupation until his departure from Timbuktu in January 2013. When did Al-Hassan join? He was a permanent key pillar of the police. Al-Hassan was a member of the organization and the groups at all times relevant to the charges in this case. In particular, he was a member of Ansar Dine. He joined and he worked at the police as soon as it was put in place from April 2012. Unlike the police Amir, Adama, and Khalid, he kept his same role as the commissaire within the police from when he first started in that role from at least the 7th of May 2012 at the latest, and continued with that role throughout the occupation. It was Al-Hassan who provided continuity for the police. You will hear evidence from witness 150, who describes 2 stages of the work of the police, covering the whole period of the charges. He describes a first stage, when the policing was being done in the streets, and a second stage with a more formal structure with a headquarters. And P150 confirms that, and I quote, "In each stage, Hassan was there," end of quote. Witness 150 also confirmed that Al-Hassan was already doing duties and tasks such as sending patrols, and I quote, "at an early stage when the groups arrived in Timbuktu," end of quote. You will hear evidence from insider witness P99, who stated, and I quote in French, "Et le second..."
And the second in charge of the Islamic police was still that Tuareg. He didn't change.
Documentary evidence, for example in an Islamic tribunal judgment and corresponding report that confirms that the accused was carrying out his functions as de facto commissaire from at least the 7th of May 2012. You will hear eyewitnesses who saw Al-Hassan at the Banque Malian de Solidarité, or the BMS, which became the headquarters of the police in the first days of the occupation in April 2012. He had his office there, and again later at the Gouvernorat when the police moved. You will see videos that show him in his office at the BMS and later again in his office at the Gouvernorat. There is an article dated the 28th of April 2012, which refers to the fact that the Islamic Police Headquarters was formally set up and already had a sign at that headquarters the day before, on the 27th of April. I've shown you that photograph that had the accused's personal phone number already on it. And you'll hear evidence that this was a number that Al-Hassan had for years before the occupation and that he continued to use during and after the occupation. From the very start, Al-Hassan voluntarily signed up to the organization's goals and what it did. In this next slide, Your Honours will see a screenshot from a video interview conducted with the accused in November 2012. And this is a shot from when he responded to a question about the salaries of the Islamic police that they received for their work. And he responded, and I quote, "It is for the sake of Allah's cause," end of quote. And in this very same video interview, when he was asked about the work of the police, he explained that it, and I quote, "it involves patrols within the town and correcting objectionable acts. Any type of reprehensible act which has been forbidden, we correct, such as drinking alcohol, smoking, and a woman adorning herself, and other such acts," end of quote. Again, in the same interview, Al-Hassan explains that the groups were applying punishments, such as cutting off the hand of a thief, executing a murderer, and flogging of others. And he said that after imposing these punishments, and I quote, "alcohol-related cases have stopped. We don't have any at all. And the same goes for theft too," end of quote. The evidence will show that Mr. Al-Hassan, like other senior leaders, was willing to be hands-on to get the job done. They led by example. You will hear from witness P65 how the execution of a sentence was considered holy, and taking part in punishments made members of the groups feel proud, so that the leaders would also do that. For instance, Al-Hassan and other leaders, such as the Islamic Tribunal members, Radwan and Qutaiba, would personally flog victims. The top spiritual guide, Al-Chingeti, helped to destroy the Sidi Yahya door. Tala, the head of the security battalions, Al-Mahdi, the head of Hezbollah, Al-Bara, a preacher, they all also helped in destroying the mausoleums. As you have already heard, Al-Hassan knew full well that these punishments were being imposed on the inhabitants and they weren't previously known to them. He explicitly said it was the first time that they were seeing these punishments and there was nothing that they could do about it, that they were all scared of these punishments. He said they feared the word jihadists and terrorists. Similarly, in a message dated the 20th of July, 2012, Drukdel, who was a senior ACME leader based outside of Mali, sent a message to fellow ACME and Ansarudine leaders in Mali, cautioning them, saying to them, don't be too hasty in applying these laws. He stated that it was, and I quote, an environment that is ignorant of religion and a people which has not applied Sharia in centuries. He went further. It's worth noting that at this stage, just because a small class of people have accepted our understanding of applying Sharia does not mean that all sections of the people have accepted it, end of quote. Hassan could also punish and discipline his investigations. I now turn to the second core function of Mr. Al-Hassan, and that was in the enforcement and implementation of the enforced rules by his handling of multiple cases of the violations of the rules and his mediation of civil disputes. Al-Hassan played a pivotal role in police investigations of the civilians who violated the organization's imposed rules. It was Al-Hassan who was involved in every stage of the cases that resulted in punishments. He was involved at the arrests, summons, detention, investigations, interrogations, judgments, and the execution of sanctions. Al-Hassan could summons and arrest suspects. And Your Honours, in this next slide, you will see an example of a summons that has been signed by Al-Hassan. And in the area with a red box, you will see his signature. Al-Hassan conducted interrogations as part of these investigations. He could even question other leaders during these investigations. This included Adama, the emir of the police, Abu Talha, the leader of the security battalions. And during these interrogations, Al-Hassan used methods that included threats of violence, and torture. You will hear witnesses, including victims and other eyewitnesses, who will testify to this. You will also see documentary evidence that shows that the police used torture. Al-Hassan also confirmed that torture took place during police interrogations of suspects. He wrote investigation reports following his investigations, a number of which were referred to the Islamic Tribunal. And I show one example in the next slide. For instance, in this report, dated the 16th of July, 2012, Al-Hassan mentioned that the suspect, and I quote, was interrogated and tortured, but to no avail. And you can also see his signature on this report, along with a stamp of the Islamic Police. Tellingly, the Islamic Police investigation reports in the possession of the prosecution that were found at the BMS and the Haute de la Maison, where the tribunal was based, were written and they were submitted by Al-Hassan. These reports are in his handwriting and many bear his signature. And the fact that this is his handwriting and his signature will be supported by evidence that you will hear, including from handwriting experts, P657 and P620, insiders, P150 and P626. And this was also confirmed by the accused himself. Al-Hassan's signatures on these reports was sufficient for police matters. Your Honours, I now turn to another example of a police investigation report that was signed by the accused. It's dated the 23rd of May, 2012. And at the very bottom, he signs as investigator. This is a close-up of the designation investigator and of his signature. The evidence will also show that Al-Hassan had the power and authority to investigate cases outside of Timbuktu city, as shown by examples of cases in Lere, Gaundam, Nyafunke, Gorma Rarus, and other localities in Timbuktu region. And he could order that suspects be brought from these other cities to the police headquarters in Timbuktu. Al-Hassan himself also says this. The evidence will show that Al-Hassan interrogated suspects and he prepared the report submitted to the tribunal. The evidence will also show that these reports had a significant impact on the judgments issued by the tribunal. His reports set out his summary of the facts, his classification of the cases into different categories, and the result of his investigations. And these reports were decisive factors in the tribunal's decisions. The evidence will show that the accused reports were relied upon by the tribunals who used them for their summary judgments. The tribunal needed these reports to decide their cases. The short duration of their so-called hearings and the result of the decisions themselves show how the tribunal relied on the results of Al-Hassan's investigation reports. For instance, in one case, when Al-Hassan's report indicated that a person confessed to adultery, this confession was the main reason to find the person guilty, and that person was sentenced to 100 lashes. Whilst without a confession, victims could receive, and usually did receive, less than 100 lashes. And my colleague tomorrow, Mr. Musa Alafi, will provide examples to your honours to show this close connection between the reports written by the accused, the tribunal decisions, and the sanctions and punishments that followed. Al-Hassan referred many cases to the tribunal, knowing full well they would result in acts underpinning the charges, including floggings and other corporal punishments, and detention for cases including adultery, witnesses will testify that they were directed to the accused or summoned by him, and insiders will confirm that he handled numerous disputes. In this next screenshot from a video, you see and you will hear evidence that the accused is resolving a debt dispute concerning the purchase of weapons. And you see weapons on the table before them. The accused also personally intervened in very personal aspects of the inhabitants' lives, such as marital disputes. For instance, you will hear evidence, including from insider witness 150, that Al-Hassan was known to pressure women to return to husbands whom they had either left or wanted to divorce. In this next slide, this is a report, again written by the accused, about a man wanting his wife to be returned to him. And you see his signature again on this report. There were other ways that the accused had an impact on people's lives. He had a say, for example, whether they could dig a well or whether a journalist could do their work and how they could do their work. And the fact that he had this power to issue permits and such authorizations also shows how important he was and his influence on the daily life of Timbuktu's inhabitants. In this next slide, Your Honour, you see an authorization for digging a well signed by the accused with the Islamic police stamp at the bottom of it. He signed, in this case, in the name of the Emir of the police, again with the stamp of the Islamic police.
Merci beaucoup.
Judge Mindua, thank you very much, Ms. Looping, for your statement. We have reached the end of the first day of the hearing. We shall adjourn for today, and we shall resume tomorrow morning at 10 o'clock with the rest of the opening statements on the part of the Office of the Prosecutor. The hearing is adjourned.